Hey everybody, how's it going? And welcome back to Copper Jacket TV. So I'm sure you guys have heard a right delayed is a right denied, and that is absolutely true. Because if you delay somebody their right for even 5 minutes, that's a right that was denied to them for that period of time, and no period of time is acceptable. Well, in some states like California with their 10-day waiting period, your rights are denied for a pretty lengthy amount of time. As a matter of fact, in California, they just recently passed a law that could see that extended out to 40 days because the California DOJ could extend that waiting period if they need more time to look up, more of your history or whatever, even though they get the results back in a matter of minutes. Regardless, there is a lawsuit that is challenging California's 10-day waiting period, and we haven't talked much about it. It's Richards v. Bonta, and this is a case that was originally filed back in, I believe it was May of 2023, and we haven't seen much from it since. But just, I believe it was yesterday, we got a pretty big update in this case. Finally, we have some major movement against California's unconstitutional 10-day waiting period. So let me tell you guys what just happened. Now, real quick before we get started, if you guys enjoy watching Second Amendment content and you support the Constitution, consider hitting that subscribe button. It's free, it only takes a second, but it really helps us spread our message. And it also tells the platform that more people are engaged with content like this, and hopefully it'll mean that we can stick around for a little bit longer. So again, with that being said, hit that subscribe button. That little alarm bell will let you know when new videos come out. Let's get to it. Okay, so let's go ahead and talk about what's going on here. So Richards v. Bonta is an FPC case that, again, challenges California's 10-day waiting period as being unconstitutional. Now, California's 10-day waiting period is a bit excessive. If you guys don't know about that, if you're watching this from another state, or maybe a state that has a similar law, basically what California does is they have you submit all of your information. So you have to go through what everybody else in the rest of the country goes through. You fill out your 4473, you fill out all your paperwork, and then it gets entered, obviously, by the person that either works there, or they use the tablets, which pretty much go through instantly, right? Well, those background checks come back within minutes sometimes. So sometimes it can be very fast, maybe there's a little bit of a delay, maybe it's late in the day, but either same day, next day, or very soon, the results of that background check are going to come back and they're going to know whether or not you're a prohibited person. But California uses that initial 10 days as more of like a cool-off period. That's kind of how they refer to it. So instead of making you wait because they have things that they need to check or things to do, they've already gone through the NIC system and everything else, and they know whether or not you're good to go. They just want to give you that cool-off time because they assume that you're up to no good. Now, Richards v. Bonta should be an absolute slam dunk, and it shouldn't really matter what judge it goes in front of because there are really no historical analogs that would back anything like this up. Just to give you guys a little bit of history here, we're talking about the 1920s when the first waiting period in California started. It started off as a one-day waiting period, and then it was like 1965. It went to a 5-day waiting period, and then after that, it went to a 15-day waiting period for handguns, believe it or not. And then in 96, they actually backed that off because recent technologies allowed them to do things a little bit quicker. And so they backed it off to the current 10 days that you're looking at now. So believe it or not, back in the 20th century, you were looking at 15 days for a period there. So it's something that's been going on since the 20s. And if you want to talk about things that are old, that's not old. 1920s, a long time ago, but it's not that old. As a matter of fact, the Bruen decision dealt with a case out of New York, which dealt with carry, and that law was created in 1911. And even though it was created in 1911, it didn't fit the historical period that the Supreme Court talked about in its Bruen decision. So we know that 1923, while it's been around for, over 100 years now, that's still not old enough to satisfy the historical requirement. And in this case, if the text of the Second Amendment is implicated, the state has to go back from the ratification of the Second Amendment, and they have to find some type of historical analog. And so far, the only thing that California has really come up with is laws that regard giving a waiting period or making somebody wait to take a transfer if they are currently intoxicated. I believe that was the only historical analog that they found is if you came in and you were just absolutely pissed drunk, they were going to make you wait until you sobered up a little bit before they handed it over. So that was the only historical analog that they could find. And even that wasn't really like a really solid law that stuck. It was just more or less like a moral code. Regardless, take a look at this. So the big news here is that the plaintiffs in this case, the 2AF, the FPC, Richards, they have filed a motion for a summary judgment in this case, and it is extremely strong. This was a motion that was filed, I believe, on July 26th, so just a few days ago from the time that I am making this video. Now, what I want to do is I want to read you guys the introduction here, and this will give you a basic understanding of exactly what the argument is here and what they're going after, and there is some pretty powerful stuff in here. So it says here in the introduction, a right delayed is a right denied, but denying access to the fundamental right to keep and bear arms is precisely what California does by operation of its unconstitutional waiting period laws. Typical law-abiding individuals in California cannot lawfully acquire a firearm without first going in person to a federally and state licensed dealer, applying for the transfer of that firearm and suffering at least a 10-day ban on the possession of that arm. Even when the state has confirmed, often within minutes of the application, that the person is eligible to acquire firearms. Then, if the defendants affirmatively allow the transfer, the buyer must go back to the dealership to take possession no sooner than 10 days after submitting the application. In California, firearms dealers must strictly comply with the state's regulatory scheme on pain of criminal liability and loss of their license to do business. In short, defendants, being the state of California, enforcement of the waiting period laws prevents law-abiding people from taking possession of lawfully acquired firearms for immediate self-defense and other lawful purposes. Even if defendants know that an individual already possesses a firearm and has passed a background check confirming that they are not prohibited from possessing firearms, the outlier regime cannot survive under NYSRPA v. Bruen. When, as here, the Second Amendment's plain text covers an individual's conduct acquiring firearms in common use for lawful purposes, including self-defense, the Constitution presumptively protects that conduct. And that is a quote from Bruen. The government must then justify its regulation by demonstrating that it is consistent with the nation's historical tradition of firearms regulation. Only then, a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command. Here, defendants cannot possibly carry that burden. No waiting period or any analogous laws existed in the constitutionally relevant historical period. Rather, no form of waiting period law was enacted for any jurisdiction in America until 1923, well beyond the relevant time period the Supreme Court permits to be considered. After all, the law held unconstitutional in Bruen was enacted in 1911. Adding insult to injury, defendants broadly discriminate against the average person by allowing nearly 24 categories of favored individuals to take possession of arms and ammunition without being subject to those same delays and burdens. This case is thus brought on the premise that defendants' enforcement of the California law violates Equal Protection Clause by discriminating among citizens in their exercise of their fundamental right to keep and bear arms. One of the downsides here is that we have a Biden-appointed judge. This judge is fairly new to the California District Court. He was, I believe he was appointed back in 2023, so it's been just a little bit over a year now. And this is a judge who went to Harvard Law and so forth, and so we kind of know where this judge stands. I don't have any history to tell you what he's ruled or made decisions on in cases that are similar to this. I just don't have that available to me. But just taking a look at everything that's available, I'm not super excited. Regardless of that point, though, there's not really any way around this. It shouldn't matter whether the judge was appointed by one president or another. If this judge just takes a look at the case itself, there's no way for California to back up this unconstitutional law. Because again, they're denying a law-abiding citizen. It's not like they're denying somebody who is prohibited, right? They're denying every single law-abiding citizen in the state of California who's already been shown to not be a prohibited person. They're denying them their rights for that 10-day time frame. And so that's what's being challenged here. The fact that law-abiding citizens, people who haven't been adjudicated for anything, are still having their rights denied. So that's kind of the crux of this whole thing, is that even if you found something where people who maybe had some type of criminal past or something like that were denied, that still wouldn't be historically relevant, because we're not talking about that. We're talking about people who've never been in trouble before, and they're still being punished, and their rights are still being delayed, thus being denied. So this summary judgment actually has, even though I'm not so sure about the judge, it still has a very good chance of happening here. So we're going to be watching this one really close, because this summary judgment was, again, just filed days ago. But if we get a win in this, I think that we're ultimately going to get a win at the Ninth Circuit. And even if they bring that up to the Supreme Court, if the Supreme Court even decided to take it, which, you know, you can't really hold your breath on these days, I think that we would still get a win there. That's how unconstitutional I feel that this law is. It's just blatantly unconstitutional, and hopefully it'll be overturned in this summary judgment soon, and California won't be able to enforce their 10-day waiting period anymore. So I wanted to share that with you guys, because again, we haven't had movement in this case in about a year, and now finally we have some major movement in the request for a summary judgment by the FPC. So again, I want to thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.